Oh yeah, I forgot to recording again. Okay, so I will start from here first lah. So in this chapter, we'll be covering what is the pleading, what are the pleadings, and what should be included, and then uh, and then what are the things to be included in the pleading, and then what if the party has failed to comply, and then yeah, the consequences. I must start recording already. Yeah, I guess so. Okay. So the pleading itself is for the purpose to state the issue and effect and the question of law to be decided by the court to prevent the animal surprise and serve as a record to the court to prevent res judicata. So what we used to see is what I have to tell you all is the prevent of animal surprise is that you cannot ask in the court for the things that you never plead in the pleadings. So if you never, so if you have been working in the litigation firm, you'll be see the whatever you will heard this quite frequently lah. Whatever you never pleaded, you cannot ask because the courts are bound by the rules of pleading, which means that you must plead first, then you only can raise the issue in the court. So this is the case on point, the Cho. The court held that the party cannot raise the issue without being pleaded. And then this is the sequence of the pleading. So for at the beginning, the plaintiff will serve a statement of claim to the defendant, and then the defendant will serve a defense. Statement of defense reply to the plaintiff's statement of claim. Then here are the other subsequent pleadings lah. Okay, for the form of the statement of claim under Order 18 and Rule 15, sorry, it states that it provides that you must state the specific relief or remedy by the plaintiff, but make sure that you are not containing any allegation. The function is for the defendant to inform the defendant on the facts and the relief claimed by the plaintiff, which means that you can only state your. I think this is what you have studied in your GP when you are drafting the statement of claim, right? You plead the facts, and then you plead your remedies, and then you plead what are you going to claim. You are not going to put any other things like, oh, I have this evidence, I have this and that, unless you are going to tell the court on which point of day you have entered a certain things, then it's the fact you can state in your statement of claim. But other than that, you cannot really. Okay, so this is the case, Metroplex Development Sdn Bhd. Actually, sometimes I have received some question, right? Some of you all might asking me, should I remember for one side or both sides from the case name? Actually, to me, right, one side is enough for you headed already. Yeah, because the logic of answering your question is you are using the correct case and apply it to your answer. You are not necessarily to answer a lot of the cases. Just one useful case that is enough. And for that case, maybe sometime when you are under anxious, then you will be like, oh God, I've forgotten the case name. So we may use the magic word in the decided case. Yes, sometimes it works because I used that before. So in this case, the court held that the function of the SOC is to plead the reasonable cause of action against the defendant, must contain the material facts. This is the point for the form of the statement of claim. So after you have done your SOC, right, you have to serve it within 14 days after the defendant enter into appearance. This is provided in Order 18, Rule 1 of your Rules of Court. Are we okay? Okay. Now, default service of the statement of claim. Okay. So the default of service means that you have the plaintiff has failed to serve the statement of claim to the defendant. So you may because as we said, you have to serve within 14 days, right? So within the 14 days, if you fail to serve the statement of claim, the defendant may apply to dismiss the claim by the plaintiff. This is given under Order 19.1, and I have screenshot the rules of court for you to have a look. Okay, so the type for the claim of damages are, so this is what we have started. This is what you have also studied in the GP also lah. Special damages, quantifiable, you must specifically plead it. But the general damages are, you are not allowed to, plead. You just plead one sentence, damages. Yeah. You see, I think most of you have done your statement of claim in the GP, you understand this lah. Okay? Now, yes, for tort, because it's like general damages is like you wouldn't be able to quantify like your pecuniary loss, and then other than that, how will you justify and how do you quantify? Okay, so the statement of defense, the purpose is for the defendant to raise the defense in respect to the plaintiff's claim. So it may include a counterclaim or a set-off. So I believe everyone already know what is the counterclaim or set-off already, right? So the service is same as the time to effect the service is same as statement of claim within the 14 days. Okay, now it comes to default of defense. The logic is same as statement of claim. If you fail to do that, the plaintiff may enter into the judgment against the defendant, but it's totally different from the others. Like once upon a time, I was a bit confused. The plaintiff entered into judgment in default. It could be different situation. So that if the defendant failed to enter into appearance, yes, you can enter into judgment in default under Order 13, because that one is JIDA, judgment in default for appearance. But now this one is because of the defense. The defendant has failed to serve the statement of defense. So the plaintiff may enter into the JID under Order 19. So there are two different types of the judgment in default. Okay. So when it comes to the judgment in default under Order 19, you may claim for the followings. Firstly is the liquidated damages, quantifiable. Then is the non-quantifiable one, and then the detinue. Detinue to me, I feel a bit because my English is not that good, so I did some research, and this is what I found. Interlocutory judgment, like delivery of property of value to be addressed. And then possession of immovable property in the final claim. And then next claim is that you are So it's given under Order 19 Rule 6. Okay, I feel that the reason why I'm going to put some the reason why I'm going to put some partial questions is because that I feel to have some interaction with you all so that this class will not look so boring by myself telling you all how straightforward, how how to convey the message to you all. So that I decided to add some partial question for you to have a better understanding. So this is the partial question for last 2 years. That year actually is like they don't have the supplementary question, and this is a very first time they don't have the conditional sitting. And then the paper is 2022 main, so that you can have a look at the question first, then you will see how the question being asked. Okay, so this is the question asking for the plaintiff to enter default judgment against the defendant because he has failed to serve the statement of defense. And this is exactly what we have just covered for last night. So for this, the first thing is you have to write out the thing like the manner of service, like how many days. Okay, so based on the fact the defendant has failed to comply, now the landlord has the option to enter a judgment in default in respect of the defendant's non-compliance. So you can list out you can write out your answer by looking at the fact what is he or she going to claim. So from the fact, right, you see 50,000 being the areas of rental. This is the liquidated, and then general damages, and then unauthorized for the unauthorized renovation. This is the liquidated one, and then vacant possession. So that this is for the claim of the immovable property. Then you may start to prepare your answer like this already. So actually, you see this. You see here the allocation of mark is 8 marks. So I believe that the allocation of 8 marks you must at least cover for like 3 to 4 things. First thing is your introduction, like how are you going to address why can the landlord enter into the default judgment? Secondly, is you are citing the Order 19 Rule 1 already, like what is the default, what is the what is the consequence of the non-compliance? Then you can go on list down the type of the damages can be claimed by the landlord because default of the defense. And then you can move on to the next question. This is how an 8 marks question goes on now. Okay. Are we okay for the question? Okay, so throughout this session, right, you will be seeing the vacant possession claim is not under Order 81 because this one, okay, the vacant, because you see, right now, Order 81 is the summary judgment. Now you already enter into a proper proceeding already. But the thing is, both sides has not agreed to settle the case expeditiously, and this is merely because of one party has failed to comply the service of the pleading. So this is clearly under Order 19 already. If you want to go for Order 81, right, both sides must have agreed to settle the case expeditiously. Either the plaintiff already know that the defendant has no case, then you can only go for the option for summary judgment. But now, in this case, you are going to a proceeding, and now the other side has failed to comply the procedure, then you will go for a judgment in default. You cannot go for a summary judgment. Yeah. Okay. So never mind. Sooner or later, the chapters will be along the topics. You will see a lot of the past year question I've chosen, then you will have a clearer picture on how is the question going to ask about. Okay. Now, the close of pleadings. Actually, what does it mean by close of pleadings? After you have exchanged the pleadings between the parties, right? After the 14 days, the court will say, okay, now is the close of pleadings. Then they will go on to set a date for the trial really. So this is the meaning of the close of pleading. So usually this will happen after at the expiration of 14 days, the service of reply, or there's no reply, but only a defense to the counterclaim, then the defense to the counterclaim. So that, which means that after the defendant has replied, so after the 14 days, that is the close of pleading. The court will tell you, okay, pleadings are closed, we will have to fix for a trial. Now, when it comes to the rules of pleading, as what I have said just now, the pleading should contain the fact, material fact, should not contain any law of, or evidence, but point of law may be raised. Like, oh, you see sometime, I am not sure whether you all have, because the third question, right? The type of the question has been changed over the years. Last time, for my time, we used to prepare the motor vehicle accident, so that most of the time we would say that negligently or recklessly, yes, these are the law, these are the point of law, so that it is allowed to be raised in the pleading. So that here is what Order 18 Rule 11 means. Now, you see omission of material fact. When you when you didn't plead the facts, which is the material right, the court will not allow the issues raised without pleading. This is the can decide the matter of the issues without being pleaded. The logic is what we have said earlier. You cannot caught other parties in a surprise. However, there are some exceptions where, in the case of Munyandi, the court has no jurisdiction to adjudicate. And in this Narayanan, there's an ex face illegality. And then in the case of OCBC and Philip B, the points raised without object by other party, although it was not pleaded, you can still raise because the other party did not object now. And then it is covered within the issues being pleaded. Wisma punca emas pemberian berhad. However, if the party has raised the objection, then you cannot ask the issue already. This is given in the case of Superintendent of Land and Surveys. Actually, this is what happened in the court, because sometimes some of the lawyers, when they prepare, they've forgotten to raise in the plea, they've forgotten to put it in the pleadings. But in the trial, when the opponent counsel are too sharp enough, they will stand up and say, Bantahan, Yang Arif, this is not covered in the pleading. So that when the judge allowed for the bantahan, then the question will not be allowed to ask in the cross-examination or in the examination in chief. Because and then because after the bantahan, right, when the objection is sustainable, then the lawyer is likely to lose the point to win his case already, because you you're objected by the other counsel that this issue is not pleaded, so that you cannot ask no matter how you twist and turn. All right, unless you can find it's covered within the issues being pleaded, then you are safe. So this is how the question asked. You see, this has happened in 2019 supplementary paper, and then you have to. The question is asking you, how could the court allow the party to rely on the point not pleaded, but on which the evidence was met without objection at the trial? So, since it's a formal question, but this is how I prepared my answer at the time now. So, you see, actually, I've been telling everyone, using a subheading is very beneficial for you all, because the point is, when you have the subheading, at least you won't be confusing yourself at the marker, because this is a formal question, but the answer is quite lengthy. What if it's more than 4 marks? Yeah, so that my general principle as the first subheading, and then it goes on to the main issue, which is the exception. And then the exception to the exception, I will put at the last, which is my conclusion. So that this is how I'm prepared. This is how I prepared my answer for this 4 marks question now. Okay, you see, this is another thing. Pleadings should contain facts only, but not evidence and law. Quick question, okay? Is it all right to write just short name of the case? What do you mean by short name, GJ? You mean okay lah, I agree for short name lah, like, you cannot lah, this one name only leh. Yeah, Muniandi. Yeah, this is one set only ma. You see, I just write out one name only. But I agree lah, some of the case I will see, like DYAM. Yeah, we can do that. We can do that. You know, sometimes the case, the name is very, very long. I agree with you. Duli, Ahmad Mulia. Wow. If you now I can only recall, but at that time, I just put DYM, counting already, because I don't think so. The practicing lawyer can really recall the case name in full. Because sometimes we are not often to recall the case name. Even for me, I also cannot recall. Yeah, so for one side only, you can just put okay, and then when you write the name, you just underline it. Okay, then you can, this is how you cite your case. And then now we come back to this question. Pleading should contain facts only, but not evidence and law, explained by reference to the decided cases and the provision of ROC. Okay, for this question, how are you go? You may read the question first, and then I will pause at here for like, I will take a break for like about 2 minutes, and then you may see, I will see the chat, and then I will see how you're all going to structure your answer. Never mind, this for this session, I purposely put it for like 2 hours, and in fact, I guess it will be taken more than that, because this is how I'm going to extend the class, because I want to see how you all going to approach to this question, instead of I am going to tell you how to structure this and that. Okay, I will give you all 2 minutes and I will see the answer from the chat group. Okay, I see one reply from the chat group. The fact is supposed to be pleaded. Wow, lengthy. Start with order 18, correct? Okay, for Sandeep's answer, yes, it's partially correct. And then I will say JJ's answer is pleading includes SOC. Yeah, uh actually this one, right? You have put too much of the explanation from your point two, point three, and point four. But your point five and point six, yes, is correct. Okay, now I see the answer from Danny. Every pleading must contain a statement with summary or care from the material facts, and then the party relies on the claim. Those facts are to be proved. It's given under Order 18 Rule 7. Yes, you may prove that as your introduction only. But bear in mind, your introduction is just for you to tell the court you already identify the question. It's not necessary to be very long. You may just put it in two sentences because the essence of your answer is based on how are you going to interpret the question and your answer. So that for every time, right, this is my strategy to structure my answer. The introduction is like one or two sentences only. It's very short, but the issue, which is your core answer, could be lengthy because how do you spot the issue? It's like now you are going to ask me what are the pleadings. So the pleadings should contain the facts only, but not evidence and law, so that the main point is on the Order 18 Rule 7. What are the Order 18 and Rule 7? You must plead the material facts. and the facts and not law, not evidence. Okay? When you have your Order 18 and Rule 7 already, actually you are on the safe side. And then you have to further elaborate, like the case of Jana, and like the case of the Middlesex County Council. I think, yes, I think JJ have already cited it out. Yes, this must be included as part of your answer. When you have this answer already, you have your introduction, your Order 1807, and the Middlesex County Council. Now, you goes to the exception. The exception where we have covered just now, the exception is the 5 points. First thing is the court has no jurisdiction to adjudicate, and then the ex fussy illegality, and then the points, the issue raised cover with the issues being pleaded, and then no objection, and then the superintendents of land surveys. If the other party has objected, then you cannot raise. This is how are you going to answer the 8 marks question. But I can see most of you have answered the questions correctly already, just that maybe you haven't structured it out loud. But the points are there already. Good to see that. Are we okay to move on to another topic? Okay. Now, under the rules of pleading, an allegation is deemed as admitted unless it is being denied by the other party. This is given under Order 18, Rule 13. It must be specifically pleaded as a denial. You must say that you don't agree to that point. You must otherwise it's deemed as admitted like what you have studied in the evidence law. Evidence law, I think the case name I've forgotten already. In the cross-examination, if you never challenge, means you already admitted. I believe this is what you have studied in your evidence law. And then it's covered in the examination of witness. I'm not sure the case is Iron Romy Helen or not, because it suddenly popped out in my mind now. I cannot recall the name already. But this is the logic of the statement of the pleadings. When you did not specifically deny, then it's deemed as admission already. Okay? Now, further and better particulars. This is also very FAQ in the question. When the party is going to ask for a lot of further information, because you know sometimes the information given by the other party is not sufficient, so that the party may apply for further and better particulars from another party. This is given under Order 1812. The case on point is Dr. Seri Ling Liao said, the court held that the particulars to be sought is confined to the matters arising out from the pleadings. So that let's say, if today I'm going to sue a company for the tortious action, but the company has a lot of the branches, like one branch is in KL, another branch is in Penang, and even in Penang, he also have few branches. So that the company will ask me, give me some give me some further information he wants to know at which particular branch. And this is how the Order 18 Rule 12 comes about. Okay? So the procedure for this is, firstly, you can do it by a formal letter. But if the request is being refused by the other party, or even the information given by the other party is insufficient, then you may apply to the court by using the NASA, which is Order 32.1. Actually, the NASA for new joiner, because I noticed today have a lot of new joiners, The NASA I'm frequently used in this subject is notice of application supported by affidavit. Okay, but however, it can be refused by the other party on the ground of delay, irrelevant or unnecessary. So this is the question. You see this one? Actually, I'm choosing out the questions I picked out are in these slides. You can find on LPQB official site now, because this is they have the 5 years papers now, so that I filter out the 5 years paper and choose the correct question applied to the slides. So you see, I will give you some time to have a look at the question, then you know how is the question going to ask and on the particular topics now. Okay, I guess everyone have read the question. Now you see, the plaintiff filed a writ and the SOC against the defendant. In the SOC, the plaintiff alleged fraud against the defendant, but did not plead the sufficient particulars. Now the defendant wants the plaintiff to furnish the more particulars of the alleged fraud, so that he can prepare to defend the plaintiff's claim at the trial. Now, the question did not specifically tells you that he wants further and better particular, but in the wording, but when you read the question already, if you're familiar enough, then you will know, oh, this is order 18 and 12, you cannot jalan around. You can only go on order 18 and 12. Now you have to start your answer already. Now, like introduction, how to advise the defendant. Then you go on the issue on the further and better particulars of your order 18 and 12. Then you go on for the procedure. And that is all your answer for the 8 marks. I know it's always easy. Okay. So maybe the defendant wants the plaintiff to amend the pleading. Actually, this is not amendment. You can, because the thing is, the defendant never denied, or the plaintiff never intended to make any amendments, so that the only thing he can go on is further and better particular topic. Actually, the reason why I'm choosing the question to put inside the slide is this is the exact question and fit to our topic. Yeah. But when you go to the real world, when you do the partial questions, right, you will see you wouldn't see that you will see sometimes there will be mixing up. Okay, can I start with order 18 rule 8 matters must be specifically pleaded? Actually, it's not necessarily though, because the point is here. He already put the statement, he already put the allegation for fraud, but just that the allegation or the particulars are not sufficient. That is the reason why the defendant going to ask him to provide or furnish more particulars. Okay? It's good for this kind of other guide you all to answer the questions correctly because from looking at the questions it's more practical. I think it's more benefit for you all to have a better understanding. Is there any questions before I move to another section? Don't even need to plead the front, just need to provide the particulars. Okay, so sometime I know that this is a common sense, but somehow you wouldn't know what is the quality of your client Sometimes your client may be thinking like, yeah, just straightforward enough need not to prove enough. I no need to put a lot of things, but somehow you wouldn't know that the things you miss out is the thing that the other party wants. Could be essential or important. So that sometimes they miss out, yeah, nothing related to evidence. Yeah. Because I see yeah. Actually, sometimes, I see. Yeah, my internet, I don't know why it's not stable nowadays. Okay, so did I miss out any point? Okay, the question, okay, so from the answer it is, first thing you have to start. What is the how do you how do you start with your question? The thing is, the first thing is your introduction. Your introduction is you have to tell the court, you have to answer to the marker that, oh, this is the issue on further and better particulars. That is your introduction you have already identified. Now it goes on to the second part of this, Order 18, Rule 12, and then the sorry, say, and then what is the case talks of here, Order 32, 1, then the parties uh may object or may refuse irrelevant and not necessary. Then you can move on to the next question already. This is how I'm going to structure the answer. Are we good? And the next section is might want to restart your router. Okay, just give me few minutes. I'm going to refresh my router. But maybe the recording will be stopped. Okay, I try to restart first. Sorry. Hello, can anyone hear me smoothly? Hi, everyone, can you hear me? Now, I just want to make sure that my connection is smooth and everyone will not feel so laggy lah. Is everything now okay and ready?
Yeah, okay, I think.
Okay, okay, good to hear that. Okay, sorry,
Yeah, I think we can proceed without wasting the time.
okay, okay. Okay, so just now where am I stop? Okay, for this question, right? Actually, I would say the introduction, this is how you identify the question. Usually the introduction is you have to tell to them that you already identified the question and then now you are going to tell the marker what is the issue. The issue is on further and better particulars. Okay, so when you already finish the sentence, then you can move on to how are you going to tackle the question. So the first part is your order 18 and rule 12. Then you then you may summarize the definitions based on the court. Then you can go on to the case of Dato Sri Lingam Singh, only confined to the matter in the pleading. Then you can go on to the procedures like formal letter, order 32 rule 1, and all that. That is how are you going to answer this question? Okay, before we move to the next section.
Yeah, we can move to next topic.
Okay. Okay, now the next one is striking out pleading. This is very often. That's why I put the FAQ here. I didn't put it for no reason. Because the striking out pleading is that another party may choose to dismiss your ask to show out pleadings, which means that your claim is no substantiate, it's no subs it has no substance, basically. So at one point of time, because I was under panic, and then the time I thought striking of pleading means that your case will be thrown out. Actually, it's not because we have few pleadings, so that the so that your striking of pleading is just that maybe this particular claim is not substantiable, and then the court wants to dismiss this one only, this part only. It's not the entire suit will be gone. So that we will cover what are the circumstances render the pleadings could be struck out by other party or by the court. So pursuant to Order 18 and Rule 19, the court may order the pleading to be struck out if scandalous, vexatious, frivolous, or no reasonable cause of action, or abuse the process of courts. And this is what Order 18 Rule 19 talks about. No reasonable cause of action. The case on point, CV land. Okay. Strikeout means can appeal afterward or not. Cannot appeal because this is the ruling only. Okay, for you all, appeal, I think most of the time when you're asked whether the matter is appealable or not, you have to see if this is the court's ruling, you cannot appeal, which means the matter is not finalized yet, so that you cannot appeal. But the court may give you a direction on whether you take up or amend, because the pleadings can be amended under Order 20. Okay? No need to take a fresh action because it's not dismiss the entire action. So we come back to here. The case on point in the case of CV land, the limitation period is expired. So based on this, is not no reasonable cause of action. And also for your all, a weak case will not suffice the ground to strike out the pleadings. This is because in the case of Banda Builders and Rian Berhad, the court held that it must be a plain and obvious case to strike out, which means that your case is weak. You still got a case. This is what we used to advise our client. No matter how, we still have a chance. We must fight. Okay, so that you cannot simply tell your client that, hey, give up lah, the case is weak. This is not professional lah. So that this is the logic of this case. So that must be a plain and obvious case to strike out the pleading. So what is the meaning of the pleading? Pleading is scandalous. Actually, it's irrelevant. So this is the case on the point. Pertamina, the court struck out a pleading filed by the defendant on the ground of scandalous. And another one is abuse the process of court. You can see the case of Sim Kie Chun. The court held that actually Sim Kie Chun, this case, I will put a highlight here because I realized that this is very frequent in the reason paper already. What actually this case it's not the short I just remember the name of me I just remember this syndication. Actually, in front is police of superintendent something because in this case, the court held that the pleading could to be struck out on the ground of res judicata. Res judicata is a Latin term refers to the matter has been adjudicated. So you cannot. So this is very often and very common when the case has already adjudicated by the court, you cannot use it for the future. You cannot use it in future already. This is what St. Catherine's case talks about. When you already have when the court already judged on this matter, you cannot use it later on. So if you want to use the case to substantiate in your fresh statement of claim, yes, Superintendent of Voodoo Prison v. St. Catherine, but I believe that at the time during the exam, St. Catherine will be easier to memorize now. That's why I use the name instead. So this case is talks about you cannot use the previous case to substantiate your new statement of claim or statement of defense. Otherwise, it will be struck out. How to apply for striking of pleadings? Same. Order 32 NASA, notice of application supported by affidavit. Yes, and this is the question exactly talks about. You can have a look first on this question. Okay, has everyone read the question already? This is reason paper lah, and this is the paper I was sitting on last year. You see, James filed a reaction against Peter. At the trial, James' claim was dismissed. He has tendered on this one so that the claim was dismissed. And then instead of appeal, he filed a fresh action against Peter for the same subject matter, intends that at the fresh trial he will tender the invoices and delivery orders as exhibit. So you see now, Peter sought your advice how to dispose the second claim. Actually, you see from here, sometimes you may be confused as to whether this is the summary judgment, but based on the fact that now you already tender the previous judgment in your new trial. So this is the striking out pleading. This is how the people set the question in the twist and turn now. They use a technical way to set the question so that from the question it's not directly asking you how to strike out the pleading, but instead they want to dismiss the claim. Okay, so from here, the introduction is based on the fact that Peter is advised to strike out the pleading filed by James. This is your introduction. Then we move on to the next point. How are you going to structure is what cause why can Peter strike out the pleadings filed by Peter? How can Peter strike out the pleadings filed by James? Then you order 80 and Rule 19. You write out the points, and then on the fact is explained in the case of Sim Kia Chun, is caught by res judicata, and then the pleadings filed by James trial of res judicata, and then how to apply for the striking of pleading order. That's all. So you see, 8 marks question actually is not that really lengthy. It needs not to be very lengthy. You just need to have your intro and then your issue and then your conclusion. Maybe you will put some time on the issue because you have to structure up what is this, and then your case on point to support, and then the procedures. So your focus is on the second part. The conclusion part and the introduction part, you just need few sentences can finish already. Are we okay? Okay. If the question was reversed, how would we advise James since he has not appropriate evidence? Okay, let me read the question again. He has failed to tender. Okay, so reverse already. Okay, JJ, this question, if the question is reversed, since this evidence is not available during the trial, right? And now the claim is dismissed. So actually, James should go for appeal relevant invoice and the DO as the fresh evidence. Okay? Okay, now he can go. Okay, so actually now he can go for appeal already now because he has the relevant invoice and delivery orders. Okay, so I guess JJ, your point is whether he has the second option. Yes, he has. He can tender this as the fresh evidence under Order 55, Rule 17. You can see the rules of court because told whether this is on which court, right? So if you are tendering this evidence as your fresh evidence, in the case of let a marshal. Yes, the principle governing the evidence during the appeal is it must not be available during the trial, and it is credible and relevant, and then there is a chance of reversing the judgment. I if I'm not mistaken now, these are the principles governing the fresh evidence during the appeal. And then yes, he can tender it during the appeal because it's not available during the trial. So this is the second option if the question is reversed. Okay? 317 is the CPC lah, but this one let a marshal is credit. The logic is the same lah. You did not, the evidence is not available during the trial lah. But thank you for highlighting this because I found it quite useful when you all ask me the questions. Okay, now this is also another question, 2020 supplementary. So you see, you can have a look on the question first. Okay, can I have your comment on how are you going to answer this question? Yes, it is. It's unlikely to amend already.
Because the plaintiff want to removed. So how come we want to advise the plaintiff? The only option for him to amend.
Yes, yes. Sometimes this is the tricky part, you know. My internet connection is not stable. Okay, sometimes this is how the question being trapped. Okay, because the plaintiff is going. You see, now the plaintiff is going to remove now. The main point is whose pleading has the problem. If yes, then the plaintiff is advised to strike out the pleading filed by the defendant. This is the essence. The plaintiff cannot amend the state of affairs, So the question from here, you have to add on something lah, because the point is here. Now, rule 13 now. The denial is specific on something mark. Okay, can you all hear me now? I just
Which
switched my
ground
connection. Yeah,
which ground are you recommending? Is it A, B, or C? No cause of action.
this is scandalous, ma. This is scandalous, ma. So scandalous basically is on B. Yeah, because the point is, the reason I think you amend is only for the plaintiff to amend himself pleading. But now he's going to remove the defendant's pleading, so that unlikely that the plaintiff can amend defendant's pleading, but instead he can just strike out. So maybe you have to add on and talks about a bit like general, because the question itself, it mentioned that he has denied, so that the denied must be specifically pleaded as per order 18 rule 13, but you must be substantiated with your facts lah, based on the fact that he did not do it very properly, but instead he put some unsubstantiable grounds or irrelevant allegations. Then you can go on to order 18 and rule 19 already. That's a very clear cut. Okay. So that the structure of your answer is your intro, like to advise the plaintiff to strike out, then the procedures, and then the issues, and your conclusions. That's all for this question. Are we okay? Okay, now we come to amendment. It's also very FAQ in the exam, so that amendment itself actually is a very technical non-compliance that will not invalidate the proceeding. Remember during the first session we talked about the non-compliance that will affect the proceeding. If the non-compliance is related to the jurisdictional matter, like when you see the wordings in the rules of court with the wording shall, SHALL, then the proceeding will be invalidate because it is non-compliance to the jurisdictional matter. However, if it's due to technical non-compliance, yes, the proceeding can still goes on. This will not be invalidated. And amendment is part of the technical non-compliance. So in this chapter, we will go on to discuss what are the mistakes that can be amended and will not render the trial null and void. The general principle of amendment is given in clara P, so that the court held that the amendment should be allowed if there's no prejudice to other parties who can be compensated with cost. And the factors considered by the court is laid out in the case of Yamaha Motor whether the application is bona fide, whether the party will be prejudiced, whether the character of the suit will be changed. So we will now discuss about the circumstances where the amendment will be disallowed. In this case, the QR Maru, the party is prejudiced, Lao Tiam Ho, delay in application. So just now, I guess someone has asked me, if you want to amend the party, right, you have do it by way of Order 15, Rule 6, not by way of 20.
Yeah,
Okay?
this is the part I'm confused. 15 or 20. This is the part I'm confused. Order 15 or amendments.
Yes, I think someone has asked me. Yes, so that you is I have to tell you that amendment is not applicable to add or remove any party. You can change the capacity only by the party himself. Okay. Whether leave of court is required for application for amendment, if before the close of pleadings, no need for the leave of court. This is given in Order 20, Rule 3. For amendment of writ of or pleading, the leave of court is required. Basically, this will be very often to see the question now. So, circumstances where the application will not be granted, this is Rafael Pura, and the application is not bona fide, and to withdraw an agreement consciously made, the QR Maru to raise a cause of action after the action commence, it shall be. These are the cases that I just simplify it into point form now. So delay in application, Rafael Pura. And now I will give you all some time to read the question. Then I will see the chat box on how are you going to address your to structure your answer. I will give you some time. I will give you some time to read, and then you may have a look. And then let's see on the chat box on how I'm going to talk about. Okay, can anyone have your view on how are you going to answer the question? Okay. Okay. Okay, generally, I see the points are quite on. I see the answers are quite on point already. Okay. Okay. For JJ's answer, I think uh it's quite on point already. Because the first thing is you have to see this is the 15 marks, unlikely to the 8 marks I've shown you earlier. So the first thing is you must talk about the general therapy. Okay. So in the case of therapy bar, just the amendment should be allowed, and then you have to cite the fair and the what is the judgment given by the court. This is your introduction. And then the factors considered by the court, Yamaha Motors. Okay, now when it comes to this question, when it comes to this question, we have to see whether leave of court is required. Now you see, 2 days before the first day of trial, this is the main point. Because the main point is 2 days before the trial means what? Close of pleadings already. When it comes to close of pleadings, leave of court is required. Order 2005. Now we have to see whether the amendment is allowed or not. You want to withdraw the admission. You want to withdraw the admission, it's totally not allowed. This is given in the case of the QR Maru we have talked about earlier. Right? Yeah, now once you already include your answer based on the fact, unlikely that uh the defendant can withdraw the admission as per the case, the QR Maru, then you will know how are you going to give your conclusion already. So you see, there must be, I know what am I saying now is very straightforward and simplified and summarized already, because when you're drafting your full answer, it's very lengthy, but you must include these few points. First is your general principle of amendment, then your factors considered by the court, and now this is since it is close of pleadings, and then what you need to do is you have to get the leave of court, and whether the leave of court will be granted, and now you're looking into the fact that this is to withdraw the admission, so that based on the fact, unlikely the amendment is allowed. Then you go on to your fifth point, is your conclusion. Whether the contention is right. Cannot because you're withdrawing the admission already means you means the plaintiff will be prejudiced, so that unlikely the amendment is allowed. You can close the file already. That is your answer. You must include at least 4 to 5 points already for this question. Are we good? Okay, now we move to the next one. Amendment of pleading with the leave after the expiry of limitation period. Yes. To further clarify, the amendment of pleading can be made although the limitation is expired, provided is within the following circumstances only. To correct the name, alter the capacity. For this one, I will show you another partial question to see how does order 20 rule 5 sub 4 applies. And then order 20 rule 5 sub 5 is very straightforward. Add or substitute a cause of action arising out from the same fact. Okay, so this is the 2022 main paper. Yeah, luckily I didn't sit for that paper, otherwise I'm trapped. Okay, so you may have a look first. Because this question is a bit lengthy, so you may reply in the chat box. If you want to look at the part 2, I will click on the part 2. Now you see the question is generally talking about the amendment for 3 parts, so that it allocates for 9 marks. So for this question, right, you can structure your answer by subheadings without introduction already, because the first part is amendment. No, actually it talks about rule 5 only, purely on rule 5. You are going to amend the statement of claim, and sorry, file the writ. He wants to amend the what? He wants to amend the writ and the defense. You want to amend the pleadings, so actually it's on 20 rule 5. So essentially the thing is talking about on the amendment of the pleadings. So you see the first amendment, the first amendment is after the service of the defense, the plaintiff discovered that the first defendant was sued in the wrong capacity, and amendment to the writ to alter the capacity of the said first defendant. This is how the Rule 5 sub 4 talks about. So if you see order 20 Rule 5 sub 4 itself, maybe I will go on to the 20 Rule 5 and paste in the chat group, so you will see better. So I just paste the wording to the chat group already. So as you can see, amendment to alter the capacity in which a party sues, so that only the defendant can make the amendment instead of the plaintiff, so that the first amendment is unlikely to be done. Okay, when you already copy when you copy the when you already have the rule 5 subform, you just copy the wording, and then you can go on to make a conclusion already. Unlikely the First Amendment can be done. Now we move on to the Second Amendment. Discover that omitted certain relevant fact. Hence, amendment is required. Okay, on this part, okay, JJ, to answer your question, right? Why only D can make the amendment? You see from the wording, in which a party sues. Like now, if which means that if I I found a mistake, I am the one who should amend. Okay, I'm the one to amend my own parties for my own parties. Not I'm making the amendment for the other parties. It's the other party's duty to make the amendment for themselves, not myself. It's not like, oh, as a plaintiff, oh, I see the defendant's mistake. Then now I'm going to do the job for the defendant. That is the logic. So that if you see there's a mistake already, it's the defendant. It's the defendant's duty to make the amendment. It's not my duty to amend for the defendant. Are you okay with this explanation? Okay. Now the second one, after the service of the writ, you see the plaintiff discovered that he omitted certain relevant fact in the statement of claim. Now he want to add in some relevant facts, right? Yes, it is allowed, provided that it is arising out from the same facts. This is given in the Rule 5, Sub 5. Add or substitute a cause of action arising out, but only limited to this extent. Okay? If other than that, then cannot. Now the third one. You see, before the service on the writ on third defendant, the third defendant died and the plaintiff wants to amend the writ to bring the action against. Do you think the amendment can be done? Okay. Why? Correct. Correct. Well, you're all very smart. Okay, because to be honest, when last year when I was last year luckily last year when I was doing this paper, right, I was practicing for this paper. I was a bit panicked, and then I almost want to put it can be amended by using Order 15(6). But when you see the cause of action, it's defamation. This is the tricky part. He never tells you what he just tell you in a very short sentence. But if you are panicked enough, you'll be trapped. Because under the CLA section Civil Law Act, this Civil Law Act Limitation Act already, Section 8, it says that the cause of action will not survive Yes, Civil Law Act. Thank you for highlighting. The cause of action will not survive if defamation, adultery, after the disease, after a person is died, so that you just need to cite this section and then close the file. That's all. Okay, now it comes to other issue. Amendment due to clerical error, typo error, or slip rule. Then you can just go on to Order 20 Rule 11. The application is notice of application without an appeal. Because sometime in the judgment, although it's sealed, when the judgment is sealed with the tiger chart, you will see the official government seal with two tigers there. It's an official judgment. And then last part of the question, which means on this right.
Yes.
Okay. So because the cause of action is defamation, when the person died already, you cannot go on further. The person died already, who are you going to sue? It's the one who defamed you die already. You cannot sue like, oh, now his estate or is to his children or anyone else will be liable for defamation. No. The point of you going to bring an action, that is the essence of the Civil Law Act. The cause of action will not survive. Because it's the particular who defamed you. It's not the other, it's not that his inheritance can be liable for his wrongdoing. Are you okay, Danny? Yes, cannot. Because
Okay.
the cause of action is not survive already, no point to amend. Okay, now we come back to the okay, thanks JJ for sharing the article. Okay, so another issue is when we talk about the judgment, right? Actually, when the judgment is sealed by the court, it's served for the perpetual effect and it served as an official record. So yeah, now we come when there's some clerical error or maybe there are some typo errors you can apply to the court for the amendment without appeal. Because just a small error, apply to the court and ask them to amend and give you a new official judgment is enough. And this is the question. But since this is a 9-mark question, maybe you have to put a bit longer on the general rule and then the factors, and then now it talks about the Order 20 and Rule 11, then you can go on. The problem is, now we are coming to the problem. When you fail to amend within 14 days, so the under Order 20 and Rule 9, the order to when you fail to apply for amendment after 14 days is deemed as your right to waive you waive your right to amend the thing already. But anyhow the court has the power to extend the period. This is given in Order 20 and Rule 9. But I found out that this one never once in my exam that asked but you may have a read or so just for your preparation. Now, when it talks about effect of amendment, right, it ties back to the date of writ, which is doctrine of relation map. And it means the effective date of amendment following the date of the writ. This is the case instant color systems and beyond the heart. Are we okay with the chapter of amendment already? Okay, we are going to a new chapter, injunction. Also very, very frequently asked. In this chapter, we'll be discussing on the type of injunction and the principles governing each type of the injunction, application, requirement, procedure, and the consequences of non-compliance. So the first thing is, what is an injunction? Injunction is an equitable relief sought by the applicant. So that most of the time when you see in the drama or in the movie, when the lawyer suit themselves up and go into the office showing a court order to prohibit someone from doing certain things, that is the injunction. Okay? Then the type of the injunction could be interim, which is an emergency injunction, and is valid for 21 days upon application, and then interlocutory injunction before or during the trial, valid until the end of the trial. Then the perpetual injunction is the so-called forever injunction because it's granted after the end of the trial. Now, the purpose of the injunction is you want to prevent another party from doing a certain act. Or another way is the court order to restrain someone from doing such act. So there are few types of the interim injunction, like prohibitory. This one is very general. Mareva injunction. Mareva injunction, we will discuss each type of the injunctions later. Mareva, Anton Peter, Eringford, Fortuna, and ad interim. So the prohibitory injunction, this is what we used to see in mostly when it involves the immovable property. Like in the contract, you will see quite often when someone has breached the contract by not selling the property to the first purchaser, but instead he's going to change his mind to sell to another purchaser. Then in your statement of claim, you will include this injunction. This is the injunction that we are going to talk about here. So that the principle govern under for the principle governing prohibitory injunction is given in the case of American Cyanamid. Monetary compensation is inadequate, serious question to be tried, full and frank disclosure, and undertaking as to damages. For this one actually, it basically means that the applicant is willing to bear the cost if injunction is not being granted. So that there is another wording, balance of inconvenience. Actually, it has the same meaning. Now, Mareva injunction actually is a second tier. Balance of how much? But maybe my lecturer never told us in this way. But I believe it's the same thing. Now, when it comes to Mareva injunction is a second tier because they have three tiers. There are three tiers of the injunction. The tiers means the seriousness because later on I will filter out for you. So the second tier is Mareva injunction. Mareva injunction is that you want to freeze the account of the defendant and also his movable assets or immovable assets. That means once you got the Mareva injunction already, then the bank account will be frozen and he cannot simply use them. He will be limited from using the money from the bank. But nonetheless, the defendant will be given a certain amount as his living cost with the court order. So the principle is that you must show that the defendant has dissipated his money or assets. In this case, Mareva, there are few principles to be fulfilled. The first thing is asset is within jurisdiction, then good arguable case, full and frank disclosure, undertaking as to damages, and the risk of the defendant dissipating the assets. Okay, now we come to tier 3, anthem pillar order. Usually this is happen in intellectual property cases because it involves incriminating evidence. And the purpose for you to get an anthem pillar order is for the plaintiff to enter into the defendant's premises to seize the incriminating evidence. So the governing principle is that there must be a prima facie case, the highest threshold. Serious damage to the plaintiff, incriminating evidence possessed by the defendant, full and frank undertaking as to damages. Now, the reason why I say that this one is the highest tier, because prohibitory, you just need serious question to be tried. Then, actually, not only anthem pillar, actually prohibitory, whatever, and anthem pillar could be also ex parte. Ex parte applies to emergency cases now. So it's at the option of the plaintiff whether it's emergency. Obviously, the plaintiff can always say it's very emergency one, and then go on for the ex parte. And the court sometimes and then decide whether or not that it's not on the good arguable case. But anthem pillar can you hear me? Yeah, now can you hear me? Okay. Anthem pillar, it requires a prima facie case. Prima facie case, which means that you already established your case, is a very high threshold, so that among the three, that's why I put it by tier. Tier 1 is prohibitory, tier 2 is Marewa, and third tier is the anthem pillar. Because the threshold that imposes are too high already. Okay, so we will cover another few. Fortuna injunction to stop a winding up action. Arringford order to obtain a stay of set aside order of injunction until appeal is heard. And then ad interim injunction to continue the ex parte injunction until inter parte hearing. So how to apply for interim injunction? This is given in Order 29 Rule 1 Sub 2, ex parte notice of application supported by affidavit. Sorry, I should remove the wording. And then now we talk about the contents of affidavit for notice of application or the ex parte notice of application supported by affidavit. So from Order 29 Rule 1 2A sub A to G, you will see a lot of the wordings, right? But to summarize it, it's full and frank disclosure. Now, the validity of the ex parte injunction is 21 days from the date of issue. This is given in 29 Rule 1 Sub 2B. And then the service must be done within 7 days from the date of order. I've screenshot and paste it here. Now the question I'm going to ask you, so this is how I'm going to clarify with you all. What is an ex parte injunction? So that in the view of urgency by the plaintiff, they may apply to prohibit, apply an ex parte injunction to prohibit another party to perform the action for such act, and then the validity is for 21 days. Then the court will, after the service, within 7 days, the court will fix a date for the inter partes hearing. Okay, so during the slides just now, right? We have been talking about ex parte and inter partes, so that the ex parte is one-sided application, but the inter partes is both sides are going to challenge during the hearing. So I will remove it as hearing, uh not the injunction. I will remove it later. Now you may have a look at this question. This is the past year question in 2019 supplementary paper, and it really talks about the injunction and other chapters. But since it's allocated for 12 marks, obviously it covers another topic. But as of now, we just covered the injunction. You may have a look first, and then I will see you all later. Okay, so from this question, right, you see, the now the Paul, now you see the question is, it talks about the DEF copy king shall pay the losses and damages totaling this sum and the interest, and that is entitled, and then Paul is entitled to 80,000 as the cost. So that in total there is more than 1.5 million now. Now he's concerning that the director and the shareholders will defy the court order from the limited information. He knows that he has this and this and this. Now he wants to enforce the judgment. But so basically, the main issue is the enforcement of judgment now. But this one I will skip first. Maybe in later on, I will be repeat the same paper again. But actually, it involves the Mareva injunction because he is worrying that he might be worrying that what if the shareholders and the director will take out the money from the bank account and move to somewhere else. so that it involves that is part of the answer only. The core answer will be on mode of enforcement of judgment. But never mind, we will move on to this one instead. This one is the main paper. Actually, for this part, right, the paper is more than this question is more than three slides. So that if you want me to move on, just type in the chat box, and then I will click on to the next part. Yes, you see, advise Paul on how he can protect his legal right and recover the judgment sum against Ma. So it's mostly is focused on the mode of enforcement. Because the mode of enforcement, there are few types: garnishing, uh, charging order, and then rate of seizure and sales, then the bankruptcy. But bankruptcy, since he already mentioned that he doesn't want to go any winding up petition, so that so you have to talk about the mode of enforcement first, and then the limitation to enforce the judgment, and then now you want to protect his legal right, go for the marijuana injunction first. You want to make sure that you will get the amount, so that it consists two topics in one question. Okay? Okay, now um I'm worried that this question you might not be really see this often now. Because this question, it talks about uh you see now the issue is during the EGM. The agenda of the EGM includes a discussion about the impugned conduct. Fearing the defamatory remarks, Hassan has filed a writ action and applied an ex parte application to stop the meeting. Now the question is whether it is allowed for an injunction to stop a meeting. What do you think? Okay, I believe at the point of time, I'm also didn't answer this question because until I flip the order 29 again I see this. Order 29 U12C, ex parte injunction cannot be granted to stop a meeting. That is part of the answer, yes. She also, and Sandeep's answer also, I think, is also makes sense. She did not make a full disclosure of the facts. Yes, so that it cannot be done. And here is the extra point. No injunction will be granted against the government. This is given in Section 29, Sub 2 of the Government Proceeding Act 1956. So that means the injunction will not be granted if you are going against the government. Are we okay? Are we okay for this chapter? Okay, we'll move on to the last chapter for today. Okay, now the chapter is on discovery. Discovery simply means that you are going to compel another party to provide a document. And yeah, what are the procedures to compel the party to provide a document, and what are the documents could be excluded from being compelled? Now this is the first, this is a general principle. Whether a discovery can be done against a stranger is not allowed. This is given in the case of Norwich Pharmaca, which is known as Norwich Pharmaca Order. In this case, is concerning on the licensed patent who is the plaintiff, to compel the defendant to provide information for him to substantiate his case. So that here is the exception, to identify the stranger. So which means that the discovery can be done against the stranger if you want to identify the stranger. So the next question is whether a stranger can apply for discovery. No, because he is not a privy in the suit, which means that he's not a party in the suit. However, the stranger can take the option for the intervener proceeding, which we have covered earlier in the earlier chapter during the intervener proceeding under Order 15. The first thing is you want to protect his legal right, not the monetary right. And then your program mining, this case, you have to be very familiarized with how to substantiate the intervener application. Now, when is the time the court may order for discovery? This is given in Order 24, Rule 3. Any time the court may order the party to serve a list of documents for the purpose of discovery by other party. And here is the Order 24, Rule 3. Now, for the order for discovery of particular document is laid out in Order 24, Rule 7. The court may order another party to provide particular documents in their possession upon the application by another party. The application is by NASA only. And then the order from court must, under Order 24, Rule 3, must first be obtained, which means that Order 24, Rule 3 serves as a leave of court. Impliedly, technically meaning. Okay, so this is the 24 Rule 7. Now, Order 24 Rule 8, the order for discovery will only be granted if necessary, because the court in the end will also filter. We have to think, have to consider whether this is necessary or not. If you simply say that I want this and that document without any substantial ground, unlikely the court will grant for the order for discovery. Now we are coming to discovery against other person. Rule 7A. So the mode of commencement if the before the commencement of proceeding is by way of originating summons, after commencement of the proceeding is notice of application. And 7A sub 3 says that OS or notice of application must supported by affidavit and the contents must follow under sub 3 lah. Okay, so that sub 4, the court's discretion whether or not to grant the discovery order, and then nonetheless go back to sub 8, the court will grant the discovery if necessary. Okay, we are coming to the exceptions. When it comes to privileged documents, right, you have to be very, very familiarized with your Evidence Act already. So I've highlighted it out from section 121 to section 132. Usually, they will always come out with section 126. Your professional, your legal privilege communication, section 126. Dato' Abachi, Dato' Anthony Sitiao and Sitiao Chuan. The exception is consent of waiver, or that is furtherance of commit crime after your, when it comes to your, what already, when it comes to your consultation already, or you are engaging to commit a crime, then your legal profession privilege is not covered. Especially 126 is very oftenly used. Okay. So the case on point for the privileged document is Dr. Pritam Singh. In this case, the patient who's suing the doctor for medical negligence and apply for discovery to compel the doctor to provide the documents. But the court dismissed the application for discovery on the ground that it is a privileged document under section 126 of the Evidence Act. However, this is no longer applicable because Private Healthcare Facilities and Services Act 1998 and regulations 2006 provides that the patient may have the right to access to the medical records via a court order. So actually, what am I going to say is so that medical report in Dr. Pritam's case, the court held that medical report is a privileged document. However, under this lengthy statute and regulation, is no longer privileged. So hopefully, if this year the question comes and asks about the privileged document for the medical record, at least you can cite this case name saying that the court held that it's a privileged document. But however, as long as you can memorize until here, it's enough already. Okay, now we come to failure to comply. Under Order 24 and Rule 16, if either party has failed to comply, the court may dismiss the action or make any orders as unjust. Okay, now we come to the past year question. You may have a look at this question. This is a 2022 question. Okay, can I have your answer by replying in the chat box? Okay, JJ, I saw your answer. What do you think about first? Okay, JJ, I think you have go a bit further already lah. Yes, yes. Order 24 rule 7 and rule 3 will be suffice already. But why don't you add on another one? Rule 8. Because within these 3 rules, you're suffice to score the mark already. So actually, oh sorry, this one is so sorry, this one is uh so this one is Danny's answer. Yes. Rule 7 and rule 3 will be enough, and you add on another one is rule 8. Because the question is now the plaintiff wants the document only from the defendant. So your order 24 rule 7 is the main answer, and then rule 3 is just like it's an introduction, like the court may at any time to ask the party to compare and furnish the document. Then you go on further to your rule 7. Rule 7 is how are you going to structure your answer? Because rule 7 talks about this and that, and then nonetheless, order 24 rule 8, that's enough for your 8-mark question. Are we okay? But order 14 rule 16, it's a bit far-fetched already because it never talks about what? Failure to comply. That's why I think it's a bit beyond the question already. So now we will look at another situation. The question also, this is a bit longer. I think I went to, because the question states D refuse. The D refuse is not that D failed to comply, right? He refused, but with the court order, if the D is still refused, okay. Yeah. D refused is because they don't have the court order. If the court already gave you the order and you don't want to comply, then it's a committed action already, Yeah, okay. Now another question will be a bit slightly different. You may have a look on the question first. please reply to the chat box if you want me to click on to another slide. Yeah. Okay, can we move to the next part? Okay, I believe we have read the questions already. The reason why I say this one is a bit different because you see the question from here, ABC maintains a deposit account with the bank. Now the company discovered that the deposit were uplifted without the knowledge and proceeds to pay. When queried, the bank said that they have the resolution to the bank appointing two senior managers as signatory. The two senior managers has resigned prior to the uplifting to the account. When contacted by the company, denied that they had anything to do with the bank accounts. Now the company wants to take action against the known or unknown perpetrators. Here is the main point. From the previous question, we already identified who is the person to be sued. But now the question from here is, you are going to bring the action against the known or unknown perpetrators, which means it's remain uncertain. Norwich Pharmaca is correct, and Rule 7A is correct as well. So that the question for the question is slightly different from previous one is because of this one. For that one, we already know who is the person. Now we are not certain who are the persons or any person to be sued. So that the applicable order here is 24(7)(a), and then the case of Norwich Pharmaca. But nonetheless, you also have to. But you may skip the order 24 Rule 3 because as of now, you don't know who is the person. You don't know who is the person. That one you may be skipped. But 24 Rule 7A and then Rule 8, you also have to include. Maybe you include the 24 Rule 3 because you must have obtained the order first. Are we okay? Okay, so I have summarized up how to differentiate between Order 24, Rule 7, and Rule 7A. So Rule 7 applies to the parties in the action already. So, however, Rule 7A applies to a stranger who is yet to be identified in the action or who is not a party in the action. That is the difference between 7 and 7A under Order 24. Okay, last but not least, any question for today's section? Okay, Rule 8A. Okay, JJ, let me read through the Rule 8A first. Actually, it's not necessary to mention because I don't think so at the point of time uh, you will have to write this because at the end of the day, this exam it's talking about the theoretical knowledge, so that whatever you write in your answer, you just go on to the point as per the question is enough. For further elaboration, sometimes the marker will not like it, so that you may stop until Rule 8 is enough for your answer. But Rule 8A maybe is for just for your own reference or for your own understanding, because sometimes you wouldn't see that as part of your answer because it talks about the duty ma. Okay, so another question I see is, how about the government disclosure? What do you mean by government disclosure? You mean the public announcement or any governmental meeting? Oh, government document it's covered under here official communication or relates to a pair of states. It's about privilege. Sometimes the privilege document will not be privileged unless we will not be privileged if it is publicated if it has been publicized to the public then the privilege will be lifted. But anyhow, any minutes of the meeting with the government will be served as a privileged document, and they have the ground to oppose your application now. Are you okay? Okay, can does anyone have any question?
I do have a question. Strikeout and dismissal is the same or difference?
You strike out someone's pleading doesn't mean that you dismiss someone's action. It can be interrelated, provided that because the reason why the wording is used striking out pleading, because as I already covered the sequence of pleadings are very lengthy, so that it's not necessarily to say that, oh, you strike out someone's pleading is you dismiss someone's action. You see the pleadings what if this is the one you're going to strike? That means everything is still in place. Are you okay?
Yeah, correct. Thank you.
Okay. Any other questions? Okay, if there's no other questions, uh, I will I will be ending this session, and anyhow you can text me you can privately text me, and then I will reply to you as soon as possible. Okay, thank you for everyone's time. Okay, so I will see you all in the next session. Bye.
Excuse me, sir.
Hmm.
Shall we prefer the next session for the trial one?
What do you mean?
Sorry, appeal topic, the next one.
I will, yes, we will. I will cover the entire syllabus within the next few sessions, so that if I found out that the time is not enough, then I will add on the sessions to cover these chapters now, because the later chapters will be very bulky also. In fact, I just managed to cover 4 chapters, and it's very, very bulky. Okay, I will see you all in the next session, and then I will share the slides to the group chat later. Okay, see you all.